I would like to call this meeting to Assembly Legislative Operations and Elections to order. We still have, at this point, time is of the essence because we still have Ways and Means that needs to go back in tonight. And of course, we have some deadlines that we're working toward. So even though we have a few members who aren't here, they're in other committees right now, working on some intense work in those committees. So we do have quorum. We will go ahead and get started. So with that, Committee Secretary, would you please call the roll?
Assemblywoman Dickman.
Here.
Assemblyman Frierson. Assemblywoman Gonzalez. Here. Assemblywoman Howdegi. Here. Assemblyman Levitt. Assemblyman Matthews. Here. Assemblyman MacArthur. Here. Assemblywoman Monroe Moreno. Assemblywoman Thomas. Here. Assemblywoman Torres. Here. Chair Miller.
And please mark Assemblywoman Monroe Moreno and Assemblyman Frierson and Levitt present when they arrive. With that, just a few housekeeping. We do have a member that is joining us through Zoom. We will hear 3 bills today, and I will take up to 30 minutes of public comment at the end of the meeting. Also, anyone testifying, whether you're here in person or on the phones or Zoom, you will have up to 2 minutes to state your testimony. With that, I would like to open the hearing on our first bill, which is Senate Bill 51. This is sponsored by the Committee on Legislative Operations and Elections on behalf of the Division of Human Service Management of the Department of Administration. It revises provisions relating to sex or gender-based harassment in the Executive Department of State Government. So with that, are there any additional presenters on Zoom or anything? Okay, so with that, when you are ready to begin, please proceed.
Thank you, Madam Chair. For the record, my name is Laura Freed. I serve as Director of the State Department of Administration. I'm joined by the Interim Administrator of the Division of Human Resource Management within the Department of Administration. We are here, as noted, to present Senate Bill 51. I will try to keep this as quick as possible in view of the time pressures. This policy bill implements certain recommendations of the Task Force on Sexual Harassment and Discrimination Law and Policy. As the committee will remember, the task force was created by the governor's very first executive order issued in January of 2019. The task force met in early 2019, and the report of the task force was issued on June 1st of 2019, and the recommendations for statutory changes were as follows. Adopt a statutory policy against sex and gender-based harassment for the state workforce. Adopt statutory requirements for a state executive branch policy specifying what sex and gender-based harassment is and defining training requirements for the executive branch employees. Codify existing harassment investigation unit personnel into statute, and adopt statutory requirements regarding harassment policies by state vendors. So if you look at the second reprint version of the bill, Section 2 of the bill establishes that the policy of the state of Nevada is to ensure that its employees do not engage in sex or gender-based harassment and that it is an unlawful form of discrimination. Section 3 mandates that the administrator of the Division of Human Resource Management shall adopt and maintain a policy concerning sex and gender-based harassment containing a definition of the term, training requirements for employees, including supervisors and managers, and the procedure for filing a complaint. And Section 5 formally creates the Sex and Gender-Based Harassment and Discrimination Investigation Unit, known as SHDIU, and details the investigation process as well as confidentiality provisions. It's important to note that this bill formalizes things that the Division of Human Resource Management was already doing. We have a sexual harassment policy available on the DHRM website, and reviewing and acknowledging the harassment policy is a typical part of onboarding for any state employee. And every executive branch employee is required to take the sexual harassment prevention course every 2 years. Additionally, we have had a unit dedicated to investigating harassment claims filed under Title VII of the Federal Civil Rights Act, and this bill simply rebrands the unit as SHDIU and codifies its presence in NRS. The bill was heard originally in Senate Legislative Operations and Elections on March 11th. It was amended and passed out of that committee on April 6th. It was then heard in Senate Finance on May 18th and amended again and passed out of that committee, which is why you're looking at the second reprint version. And so, unless you would like me to go deeper into the details of the bill, that is all I had, Madam Chair. Thank you very much.
Thank you. And with that, members, do we have any questions? Okay, we will begin with Assemblywoman Thomas.
Thank you, Madam Chair, and thank you for the presentation. I'm glad to see that the state is implementing this sexual harassment. But my question is, would sexual harassment, wouldn't bullying be almost a twin, so to speak? And I was just wondering why that wasn't in this bill.
Laura Freed, Department of Administration, for the record, through you, Madam Chair, to the Assemblywoman Thomas. Thank you. That wasn't really in the scope of the governor's executive order. This was really designed to be a study of law and policy around gender-based harassment, so sexual harassment as well as gender expression harassment. I agree with you. Bullying could encompass that. And I think I think Mr. Richardson could speak more to the studies or the investigations that SHDIU has on its plate, but I think we would probably treat an allegation of bullying very similarly to something that would be a specific harassment allegation about gender.
Thank you. Follow-up, Chair, please?
Yes, please.
The reason why I was asking about the bullying aspect of adding that to the bill is because generally with sexual harassment, sometimes it's not, female to female or male to male, and then that's when we encompass the bullying aspect of it. That's why I was wondering. Thank you. And thank you, Chair.
Thank you, Assemblywoman. With that, our next question will be from Assemblywoman Dickman.
Thank you, Chair. Is sex and gender-based harassment a big problem in our executive department of state government? Could we get some examples, maybe?
Sure. Good afternoon, Frank Richardson. Good afternoon, Chair and members of the committee. We take about 155 cases a year that are submitted to the Sexual Harassment and Discrimination Unit. So we consider that a significant problem. Of those, about 60% are sexual harassment or some type of gender discrimination. The rest have to do with other types or forms of discrimination like ageism and other, not too many other cases.
Thank you, sir. Do you think we have this problem in the legislature? I mean, I certainly wouldn't want to be breaking these rules. I'd like to know what they are.
Assemblywoman, one, where the bill's referring to the executive branch, and we're in the legislative branch, but also we do go through our ethics training, and we do have, those rules, and I believe the manual's still on our desk on the floor, so, we should be clear at this point where, which behaviors and the type of conduct that is, acceptable and what isn't. Do you have another follow-up question?
Do they have a similar manual in the executive branch?
Would you like to answer that?
Madam Chair, Assemblywoman Dickman, we do. We have, again, the harassment and discrimination policy is available for anyone to read on the DHRM website. That's hr.nv.gov. And there is also a state guide to employee conduct, which also covers harassment. And again, everyone has to take the refresher course every 2 years. So, and I will say in response to this bill and the task force, we have been polishing up our state harassment policy, and it's pretty much ready to go in response to this bill.
Thank you. Thank you, Chair.
You're welcome, Assemblywoman. I would also just like to make a comment based on something that you said about that you have 150 complaints filed a year. And so if I'm, anecdotally or just making assumptions, that's 150 cases of people that had the courage to come forward to file. That doesn't mean there were just 150. It's just 150 people that actually had the courage to come forward. Would you agree with that?
I would. Frank Richardson, for the record. We know that when we advertise and get the word out about the Sexual Harassment and Discrimination Unit, that we get more reports. So it's important that we continue to keep this in the forefront and that we pay attention to what's going on and update our policies. Because as we are out in our community with our employees, we do get more reports. And a good example of that is the governor's executive order. We almost doubled our cases after that executive order came out, and that's significant. So we need to continue to push that needle so that we can get everybody to file their complaints.
Thank you. Next, we have a question from Assemblywoman Gonzalez.
Thank you so much, Chair. Assemblywoman Gonzalez, District 16 for the record. Thank you so much for this bill. I think that as someone who's done a lot of research in sexual harassment in the workplace, it's really easy to get a lot of this stuff mixed up when it's hard to define. So thank you. And so my question really is, who are these investigators in the unit? And then my other question was, what is in place for retaliation? So like, how do we ensure that folks aren't being retaliated against? I don't know if I missed that in reading the bill. Thank you.
Frank Richardson, for the record. Thank you for your question, Assemblywoman. We do have a policy that addresses retaliation. Retaliation needs to be handled at the department level because when we conduct the investigations, that report goes back to the director of that department, and then the department decides how they're going to deal with that particular issue. If any form of retaliation comes up, we suggest that the complainant come directly back to the Sexual Harassment and Discrimination Unit to file an additional retaliation complaint. And if you're familiar with Title VII investigations and how they work, the standard for retaliation is much lower than the initial complaint for Title VII, which is pervasive and severe. So we get in a retaliation complaint, it's immediately investigated and typically addressed right away. And I'm sorry, you had a second question. I apologize.
The first question was who are the principal investigators?
Okay, very good. Frank Richardson, for the record. We currently have 3 investigators assigned to the unit and 1 supervisor. That's only 1 more investigator than when the unit first started in 2003. So it hasn't grown much over the years, but certainly our workload has.
And then my last question, are these like independent folks? Do you work within the office and you're like assigned to this unit, or is this solely your job?
Yes, thank you again for that question, Frank Richardson, for the record. These are employees that work for DHRM who are assigned to the Sexual Harassment and Discrimination Unit full-time. They're typically titled as compliance investigators and then the supervisory compliance investigator.
Members, any additional questions? Assemblywoman Torres?
Thank you, Chair, and thank you for the presentation. I really do love the intent of this bill, and I'm just wondering why we didn't include other types of discrimination that are included in Title VII, like national origin, religion, color, and race.
Thank you for the question, Frank Richardson, for the record. When we address this particular bill and the language with discrimination, it's kind of a catch-all for us in our unit. We investigate all Title VII cases that are listed under federal law. So every one of those that you mentioned, we would investigate.
Thank you. So just a quick follow-up. So then would the language in this piece of legislation then be applicable to all the other forms of discrimination captured in Title VII?
Thank you for your question, Frank Richardson, for the record. That's our intent and what we contemplate when we put the bill together.
Yeah, thank you, Chair. And I appreciate that. And I just wonder if it should be made more clear in the legislation that it captures those other forms of discrimination. I just know, and harassment, because I just know from conversations with other legislation that we've seen in previous sessions and this session that we've had to go back and codify that and address that definition of discrimination or harassment. So I'm just wondering if we should maybe do that at this, if that would be something that would be considered.
Madam Chair, Assemblywoman Torres, Laura Freed for the record. Again, this goes back to, our bill is trying to answer the scope of the governor's task force, and because we were already conforming to Title VII by having what we used to call the EEOC unit, what we now call SHDIU, investigate Title VII to conform to federal law anyway. We hadn't considered that, but we're amenable to it.
Thank you for that. Seeing no other questions, I'd like to open it up for those who would like to come forward and testify in support. So if there's anyone here in the room that would like to come and testify in support. Okay, not seeing anyone. Is there anyone on Zoom, not seeing anyone, or on broadcasting? Can you open up the telephone lines for anyone who would like to call and testify in support?
Yes, thank you, Chair. Good evening. If you would like to testify in support of SB 51, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 540, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, Chair.
Proceed.
Good afternoon, Chair Miller and members of the committee. For the record, my name is Serena Evans, SERENAEVANS, and I'm the policy coordinator for the Nevada Coalition to End Domestic and Sexual Violence, here today in support of Senate Bill 51. Having clear written policies and a clear procedure for reporting and investigating incidences of these forms of harassment will ensure that state employees know there is zero tolerance and will direct them, and to Chair Miller's point, may even encourage them to report and where to go if they unfortunately experience these types of harassment and or violence. We're in favor of this legislation, as everyone deserves a safe working environment, and the state of Nevada can lead by example in adopting this important legislation into state statute. Thank you.
Thank you.
Thank you, caller. We are currently taking testimony on SB 51. If you would like to testify in support of SB 51, please press star 9 now to take your place in the queue. Chair, you have no more callers in support at this time.
Thank you. Do we have anyone who's on the line to, well, nope, before I do that, I have to open it up in here. Is there anyone here in the room that would like to come forward to testify in opposition of SB 51? Okay, not seeing anyone. Broadcasting, do we have anyone on the line that would like to testify in opposition to SB 51?
Thank you, Chair. If you would like to testify in opposition of SB 51, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 120, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen as in the Assemblywoman. So my dissent is twofold. Number one, as the agency mentioned in its presentation, I think the unit is duplicative of the EEO unit that it already has, but then also believe the statute that's partially sought to be revised with this legislation is so deficient that I've submitted an amendment, and if the committee would be willing to consider that amendment, I would be in support. With that, Madam Chair, thank you, and I yield.
And Mr. Cohen, with that, in order for it to be a testimony in, well, I'm sorry, you're actually correct, because we are in opposition. Thank you for that. Broadcasting, can we go on to the next caller?
Yes, thank you, Chair. If you recently just joined us, we are currently in opposition of SB 51. If you would like to testify in opposition, please press star 9 now to take your place in the queue. Chair, you have no more callers in opposition at this time.
Turn the microphone off. I will open it up for anyone wishing to testify in neutral of SB 51. Is there anyone here in the room that would like to come forward? Not seeing anyone. Broadcasting, do we have anyone on the line that would like to testify in neutral for SB 51?
Thank you, Chair. If you would like to testify neutral on SB 51, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. And with that, I would close the item for testimony. Would our presenters like to come back and make any final statements?
Only to say thank you, sorry, Laura Freed, Department of Administration for the record. Only to say thank you for hearing the bill, and we look forward to working with you on it.
Okay, thank you so much. And with that, I will close the hearing on SB 51. Okay, I will go ahead and open the hearing on SB 292. This is a bill that is sponsored by Senator Lang, and it revises provisions on relating to elections. And so with that, Senator Lang, when you are ready. Now, do you have some co-presenters I see in the Zoom, Mr. Schrager?
Mr. Schrager,
Okay, so it would just be the two of you presenting?
yes.
Okay, so when you are.
So I'll present, and then if there are questions related to election law, he's available.
Okay, when we get to the question part, usually what we do is, just to keep things organized, is members will address the questions directly to you, and then you will defer to Mr. Schrager when appropriate, okay?
Sounds great. Thank you.
All right, thank you. Please proceed when you're ready.
Thank you. Good afternoon, Chair Miller, members of the Legislative Operations and Elections Committee. Thank you for allowing me to present Senate Bill 292. For the record, I'm Roberta Lang, representing Senate District 7 in Clark County. I will walk the committee through the bill, outline the purpose, and then answer any questions. I'm pleased, as you know, to be joined by Attorney Bradley Schrager, a Nevada election law attorney, who will help answer questions you may have as well. So, in the bill, sections 1, 4, and 5 of this bill relate to providing a straight ticket voting option. Section 1 and 5 provide that all ballots in any form must permit a voter to vote for all the candidates of one political party on the ballot in a partisan race by marking the name of the political party at the top of the ballot. Section 4 requires that already existing voter education programs provided by the Clark County election offices incorporate in their program information on how to cast a straight ticket vote if a voter so chooses. I'll take this moment to highlight some important points. The straight ticket voting option is just that, an option. A voter can choose to cast a straight ticket vote, or they can choose to cast a vote in each individual election. There is no mandate. If a voter chooses a straight ticket voting option, but does decide to cast a vote in an individual race for a candidate other than the candidate with the party they choose, the selection of the individual candidate will supersede the straight ticket voting option. This will ensure that no matter what option a voter selects, their intent is held paramount and their government reflects the will of the people. The goal of straight ticket option is to help encourage voters to cast their vote in down ballot races, including our own legislative races that are far too often skipped, which reduces voters' say in state government. By providing this option, we create a smoother, simplified voting method for voters so that voting experience can be more accurate and efficient. Next, in sections 2 and 3 of this bill, Nevada law as it relates to third-party ballot access. Let me state first and foremost that this should not affect our existing third parties. IAP, Libertarian, which will continue to qualify and have ballot access as a result of gaining at least 1% of votes in congressional races. Additionally, this does not change or affect in any way the requirements for independent candidates to qualify and run in any particular race. Those will remain the same. Instead, this section is meant to align laws so that they are in mainstream nationally and consistent with our initiative petition laws. Section 2 requires the signature petitions necessary for new third parties to obtain ballot access must be equally divided among the petition districts and sets the deadline for submission to June 1st or the Monday following June 1st if June 1st falls on a weekend, and adjusts the deadline to file a challenge to the signature petition to from the fourth Friday in June to the second Monday in June. This update aligns the disbursement of those signatures requirements to be consistent with existing requirements for initiative petitions. And finally, by slightly moving up the submission and challenge dates, this should ensure that there's enough time for courts to review and rule on legal challenges without the fear of ruling coming out at or near the printing ballot deadlines. Section 6 of this bill requires the governor to appoint a person who is of the same political party as the former senator of the same requirements that exist for filling legislative vacancies at the state level. The next components relate to how to fill vacancies that arise for representatives in Congress. Sections 8 and 9 of this bill require a candidate for a major political party to be nominated at a special primary election before the special general election and requires the governor to specify a date for a special primary election to be held not less than 60 days before the date of the general election, special general election. Section 8 also removes the requirement for a special election to be conducted not more than 90 days after the issuance of a proclamation by the governor if a vacancy is caused by a catastrophe. Sections 7, 10, and 14 of this bill make conforming changes by 1, removing definitions relating to a catastrophe, and 2, revising certain references relating to such provisions. The intent of these changes are to fix the conflicting and confusing Supreme Court and Secretary of State determinations that emerged after the 2011 election to fill Representative Dean Heller's seat to ensure that there is a primary election when there is a special election to fill a U.S. House vacancy. I believe providing a primary election to choose nominees ensures greater participation in our democracy and produces a more representative government. Sections 11 and 12 update legislative vacancy laws to address some of the complaints we heard from county commissions and their roles in filling those vacancies. They made it clear to us that they wanted to remove themselves from the vetting process as much as constitutionally allowable. Sections 11 and 12 of this bill 1, require the majority and minority leader of the House, of which the former legislator was a member, who is of the same political party as a former legislator, to submit to the board or boards of county commissioners, as applicable, a list of qualified nominees to fill the vacancy. And 2, require the board or boards of county commissioners to fill the vacancies by appointing a person from a list of qualified nominees. If the former legislator is not from the same political party as the majority or minority leader of the House, of which the former legislator was a member, Sections 11 and 12 require the board or boards of county commissioners, as applicable, to establish an application process by which persons may file applications with the board or boards to fill the vacancy. Section 13 of this bill makes conforming change to require a nominee or applicant to fill a vacancy to file a declaration of eligibility with the board or boards of county commissioners. And finally, Section 15 of this bill removes NRS requirements on the internal structure of political parties that we felt may violate the U.S. Supreme Court ruling in the Democratic Party versus Wisconsin. With that, I'm happy to answer any questions.
Thank you, Senator. Members, do we have any questions? One moment, please. Thanks. Okay, members, any Any questions? Assemblyman Matthews?
Thank you so much, Chair, and thank you, Senator. Appreciate the presentation on the bill. Regarding the straight ticket voting, my understanding is that the trend nationally is actually for more and more states to go away from this mechanism. So, for example, Utah, I think, is in the process of abandoning this approach, and I think the data there actually shows that voter participation, especially in a lot of down-ballot nonpartisan races, has actually dropped, and it's often being attributed, to this. And a lot of people who are pushing for the repeal have spoken to voter confusion in terms of understanding that when you vote, you check the straight ticket box, you're not done, and a lot of and so the result is again lower participation in a lot of those races. Is that a concern of yours? What processes might be in place to make sure that voters really have a good understanding of how this is going to work? Thank you.
Thank you, Assemblyman, to the chair, through the chair to the Assemblyman.
Please go direct.
Thank you. I hear your concerns, and I've done a lot of research, and I've talked to the county clerks. And as far as the voter education, which I think is hugely important, people in the counties are used to getting their voter books. The county all the counties have said that they're going to educate the voters on how to do that. As to your question about, the trend and how the trend is changing, in my research, what I found is that more people did straight ticket voting, and then when control of the state changed parties, the straight ticket voting went away. And so that is what I have found, and maybe Mr. Schrager has something he wants to add to that.
Yes, Madam Chair, may I speak directly to the member? Can you hear me?
I just realized you couldn't hear me because you weren't in the room.
Okay.
Yes, please go direct.
Okay, very good, thank you. Assemblyman, you are ostensibly correct in that over the last 25 years, there has been a move among certain states away from straight ticket voting. That always has to do with particular give and take and flow of politics within a state. I do not think that there is a correlation between straight ticket voting and decreased voter participation. In fact, quite the opposite. But in this regard, offering it as an optional choice, I think, along with educational opportunities, elections change all the time. Balloting changes all the time, whether it's to electronic machines or to mail voting. Any of those changes require voter education, and I think that that what the Senator has tried to build in here are the appropriate mechanisms for educating voters regarding straight ticket voting as an option for them to exercise if they so choose.
Thank you. One follow-up, Madam Chair?
Yes, please.
Thank you. Regarding, I believe it's Section 11, but it's one of the sections dealing with filling vacancies and sort of the shift away from how it's done now, predominantly locally, to shifting some of that authority to the state. I guess my one question on that would be, why do we think that, at the state level where disproportionately, we see representation from our largest counties, why the shift there for a vacancy that may be for a seat that's locally, where the folks locally on the ground may be more in tune with local issues and local needs? I guess what I'm saying, as a corollary to that, is there a problem that this is seeking to address that is inherent to the current way that we're filling those vacancies? Thank you.
Thank you. And could I ask a clarifying question? So which race in particular are you speaking of?
No, I'm asking why do we think that this authority, or why this should be shifted sort of to the state level as opposed to the old way of doing it, keeping it locally, where so the commissions would have presumably a better understanding of local issues and concerns. Does that clarify it?
Thanks so much. That helps a lot. So in the legislative races, we have heard over and over from the county commissioners that they don't want to do this. It is in our constitution that the county commissioners are the body that will appoint. And so in talking to them, what they wanted us to be able to address was to do the vetting process, and the commission, the local body, would decide, and based on the recommendations that were given to them.
And Madam Chair, if I may just be put into one last. Certainly. And this is sort of unanimous across the counties that they're sort of generally across the board calling for this? Is that correct?
So this is something that I actually presented to them, but they had expressed the concern as it goes to the rural counties. So in the rural counties, it may be a bit different, and they wanted the opportunity to be able to have a say and to be able to have multiple candidates that they might be able to choose from, and not to just have one presented to them. And that's why in the language in the bill, it talks about multiple candidates, just to give them that opportunity to have a say.
Senator, thank you so much. Thank you, Chair.
Sure, thank you.
You're welcome. Next question is from Assemblywoman Dickman.
Thank you, Chair Miller. And thank you, Senator Lang. It's good to see you again. My question has to do with, because I've been involved with the parties for many, many years, since I actually first moved to Nevada. So this bill repeals Section 15 without replacement all language of NRS 293 dealing with precinct meetings, county and state conventions, and organization of state and county central committees. Without that framework in place, what authorizes county and state parties to exist? And I guess as a second question, would anyone who felt like it just be able to set up a party, a state party, when it's not outlined in statute?
Thank you, Assemblywoman, and it's great to see you too. To address your question, and then I'm going to ask Mr. Schrager to take it a little bit further. As you know, I'm a former state party chair. So this language at some point probably gave me some direction when I was chair. When I finished my term as chair, I realized there was stuff in this language that really wasn't applicable anymore. And I also knew about the lawsuit, which I'm going to ask Mr. Schreiger to talk about, the Democratic Party versus Wisconsin, and what happened there, because they had language in their NRS, and it is now removed because of that Supreme Court hearing. So, Mr. Schreiger, if you talk about that, please.
Certainly. Thank you very much, Madam Chair. Once again, Bradley Schrager, to Assemblywoman Dickman. The sort of gist of your question, Assemblywoman, sort of presumes that the NRS is in fact the sort of fountain of parties' existence, when in fact the things that are being repealed here are ways in which the state has attempted to control the inner workings and the association rights of parties. Parties exist not only on a state level through other statutes, but also by virtue of their relationship and their chartering and their agreements with national parties. So the very existence or the regulation of the existence of parties flows through other statutes. What these statutes have attempted to do for a very long time is to control the ways in which parties organize themselves, act, send individuals to state conventions or to nominate presidential candidates, those sorts of things. Those things are actually flatly unconstitutional, and the statutes that are at issue here are being repealed because they are defunct. There is no way they could operate if any court actually was asked to look at them or anyone challenged their operation. So while they may have functioned as a guide for many people, I think what they've done over at least my tenure as an election lawyer is to confuse people who refer to the NRS regarding these provisions, when in fact, even if a party itself agrees to follow them, they don't have to, and they cannot be penalized for not following them. Those sorts of statutes that say, how to run your precinct level issues, or how to run your state convention. Not only in Wisconsin, which was the sort of fundamental case on this, But I remember back in 2008, there was a Nevada case that involved the Democratic primary, presidential primary, and at issue was whether or not the Democratic Party could hold precinct locations within casinos or caucus locations within casinos. And it was argued that this was not authorized by the NRS. And what the federal district court said, perfectly in keeping and essentially sort of predicting national Supreme Court law, was the state acting through the NRS cannot control how a party associates and produces candidates or conventions or those sorts of things. So for many years, these statutes have been on the books, but they are essentially dead letters. They are essentially defunct. So that's really the sort of driving force between this, is to finally clear these out so that there's no further confusion regarding what a state can and cannot regulate as far as state and local parties go. Thank you.
Thank you. And Madam Chair, may I follow up quickly?
Yes, please.
Thank you. So what are you saying? There are other statutes that would dictate what we do, or would it be up to the parties, or where would we go with this for guidance?
Thank you. Once again, this is Bradley Schrager for the record, Assemblywoman. There are other statutes that govern, for example, how a party becomes a major party, how a party gets on the ballot as a minor party, how parties exist in the first instance. Most everything beyond that is within the party's right of association. So as long as a party is not doing something that is flatly illegal, parties have a right under the United States Constitution to, in essence, develop their own guidance as to how they put on their state conventions, or how they produce delegates from the precinct to the county level, or even if they do that at all. Those are internal party functions and deliberations that a state cannot control. So the sort of answer to your question is, sort of blessedly, it's up to the parties to determine how to do those things. And that these statutes over time have led to the impression that that's not true. And so it's a way, in essence, of reinvigorating the internal democracy of parties to determine for themselves how these functions will be carried out.
And if I might just add,
Quick. Go ahead.
Senator, please proceed.
And if I might just add an example, so we're all familiar with the presidential, every presidential, we have caucuses or some form of way to nominate the president. And those in the party structures, and I'm sure it's the same with both parties, you decide what your caucus to convention plan is going to be. And that plan then goes to the rules and bylaws of each respective party. And the rules and bylaws of those parties decide how that's going to happen. It isn't decided in our statute. And as it refers in the statute how it is right now, it talks about the precincts and it talks about how many people can go to the convention. I can tell you that if we had followed that, our convention size would be over 4,000 people. Now there are more places in Las Vegas. At the time when I was chair, there were 2 places where we could hold a convention. And so either you do a convention where you have people in one room and people in another room, there's just no way. But I think the bottom line here is, as much as we would like to have some clear definition maybe in the statute, it isn't the purview of the statute to provide this to the parties. They are their own organization.
Thank you, Senator. So, may I, Madam Chair?
Yes.
I'm just trying to understand how the regulations would be set then. Would they be set by the different county parties? Could Washoe base it on population and Clark base it on something else? And could we end up with, per capita representation totally different in Washoe and Clark, and then in the rurals? How would we do this without guidance? Without this guidance?
Senator, do you understand the question?
Yes.
Okay.
Thank you for the question. So it would be, the onus would be on the party. It's an organization. The onus would be on the party to figure that out. Each county has their bylaws. and then there's the state party that is the umbrella over all of them. And so it would be up to, and I'm sure they're already kind of in your bylaws. It would be up to the party organizations, counties, and the state to figure that out. And if they want to put it in their rules and bylaws, like our convention should be this, how many people should attend, what should the representation be? As a former chair, that's my recommendation.
Thank you, Senator, and thanks for the questions, Madam Chair.
Thank you. Members, any additional questions? Okay, not seeing any additional questions, we will go ahead and move on to testimony. I will limit testimony for each position to 20 minutes for support, 20 minutes for opposition, and 20 minutes for neutral. And so with that, if there is anyone in the room who would like to approach, just give me a moment. I'm just need a moment to set my timer here. So again, please make sure that you state your name, your first and last name, and spell it so we can, so it's correct for the record, and then you will have 2 minutes.
Thank you, Chair. For the record, my name is Maria Teresa Lieberman Parraga. That's MARIA-TERESA-LIEBERMANN-PARRAGA. And with that, I'll make my testimony even shorter. I am the Deputy Director of Battleborn Progress, and we are here in strong support of SB 292, and thank Senator Roberta Lang for bringing this forward. We are in support mostly because this will really help address drop-off in state and local elections. A recent study by Keystone Research Center in Pennsylvania, a state that took away straight ticket voting, showed that the elimination of straight ticket voting will lead to an average reduction per district of 1,241 votes in state Senate elections and 845 votes in state House elections, numbers that are greater than the margin of victory in 1 Senate and 4 House districts per year. Creating a straight ticket voting option will improve full ballot voting and ensure that more equitable vote distribution in down ballot contests. So please support SB 292, and thank you for your time.
Is there anyone else in the room that would like to come forward to testify in support? Okay, not seeing anyone. Broadcasting, do we have anyone on the line that would like to testify in support of SB 292?
Thank you, Chair. If you would like to testify in support of SB 292, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of SB 292, please press star 9 now. Chair, you have no callers in support at this time.
Okay, thank you. With that, then I will close testimony in support and open it up for anyone that would like to testify in opposition. If there's anyone in the room that would like to come forward and testify for opposition.
Good afternoon, members of the committee and Madam Chair. My name is Janine Hansen. I'm the state president of the Independent American Party. We oppose SB 292, particularly the portion which imposes straight ticket voting. Straight ticket voting exists currently in only 6 states and has been abolished in 16 states. Straight ticket voting is particularly harmful to minor parties who do not field candidates for every office. It also disenfranchises nonpartisan voters. As of January 2021, nonpartisan and minor party voters composed 640,000 voters, which is 1/3 of all Nevada voters. Straight ticket voting has been found to be very confusing to voters. Straight ticket voting hurts nonpartisan races like judges and school board, which are at the bottom of the ballot, because voters think they are finished voting. The voters also fail to vote on ballot questions and propose constitutional amendments. results. Straight ticket voting discourages voter engagement in trying to obtain good information about those running for offices. It essentially encourages lazy voting. Although the sections of the bill imposing earlier deadlines for minor parties do not affect the Independent American Party because we have secured our ballot access, we oppose those portions of the bill as well. Why do we seek to make it more difficult for people joining together as voters to organize a political party? Is it fear of competition or perhaps suppression of voters with alternative ideas? I served as the National Ballot Access Coordinator for the National Constitution Party in 96, 04, and 08. It is very difficult for minor parties to gain ballot access. In fact, in some states, it is nearly impossible. Is it the objective of this legislation to maintain the monopoly of the two parties? For 26 years, Nevada Families published the voter guide, of which I was the publisher and editor. That reported answers of questions for candidates on statewide, legislative, county commissions, school board, and sheriff to questions on critical issues.
Hanson, your 2 minutes are up.
Thank you. In closing, we oppose straight ticket voting as antithetical to the goal of an informed electorate. Thank you.
Thank you. Not seeing anyone else in the room, and thank you, Ms. Hanson. I know you know the routine that you can hand in your printed statement so that we have the full thing for the record. Thank you. That goes for anyone on the telephones as well. So with that, not seeing anyone else in the room, broadcasting, do we have anyone on the phone that would like to testify in opposition of SB 292?
Thank you, Chair. If you would like to testify in opposition of SB 292, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 544. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Yes, thank you. My name is Gennady Stolyarov II, first name Gennady, last name Stolyarov. As chairman of the U.S. Transhumanist Party and chief executive of the Nevada Transhumanist Party, I strongly urge you to oppose SB 292. I note that I'm acting as a private citizen on my personal time, not representing any agency of the state of Nevada and not using state equipment to provide any testimony on this bill. SB 292, especially Section 2, exacerbates a highly polarized political situation, disenfranchises supporters of minor parties, and restricts voter choice. I submitted a detailed comment letter explaining why this is so. The equal apportionment requirement for petition signatures makes it practically impossible for a minor party to qualify by petition. It would be almost effortless for a major party to challenge petitions submitted by minor parties by counting the signatures from each district and noting any difference whatsoever, even literally one signature. The amended Section 2 would not allow any room for deviation from a strictly equal apportionment. The threshold of petition signatures required in Nevada is already immensely high. No party has been able to meet this onerous threshold since 2011. Section 2 would compound the difficulties and enable a major party to thwart every minor party's petition forever. The June 1st deadline reduces the time to comply with a more stringent requirement. The U.S. District Court for the District of Nevada even struck down a somewhat less burdensome deadline of June 10th during the 1992 case of Fulani versus Lau, discussed in my letter. Honorable legislators, do you really wish to support legislation that so clearly limits and suppresses voter choice? How is this consistent with a stated commitment to voters' rights? SB 292 would reinforce America's bifurcation into two distinct blocs, which are engaged in an ever-intensifying struggle with one another to the detriment of any actual progress on policy and any solutions to pressing problems. Minor parties can help provide solutions that bridge partisan divides. Please do not shut us out of the process. Please reject SB 292. Thank you.
Thank you.
Thank you, caller. Caller with the last 3 digits of 304. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, committee. My name is Jim DeGraffenreid, DeGraffenreid. I'm the National Committee Man for the Nevada Republican Party, and we are strongly opposed to this bill. SB 292 is presented as a straight ticket voting bill. That small part of this bill is bad enough because it discourages voter engagement and informed voting, and that's the worst thing we can do in our current polarized and hyper-partisan political environment. Sections 8 and 9 change the way vacancies are filled for state and federal legislators. SB 292 requires the state of Nevada to hold a special primary election in place of the current internal party nominating process to fill such a vacancy. That means 2 complete elections to fill a single vacancy. We don't know the expense because the Secretary of State declined to give an estimate on a, quote, vacancy which may or may not occur, end quote. Based on typical election costs as stated in fiscal notes and other legislation, the fiscal notes for this bill are understated, however, by millions of dollars. Sections 11, 12, and 13 give the legislature more power over the process of filling legislative vacancies at the expense of counties. The Nevada Constitution rightly gives county commissioners, who are the closest to the people, the power to determine the process to fill vacancies. However, under this bill, the list of nominees to choose from would be provided by the legislature, which inappropriately limits local control. If that's what the people want, it should be done by a constitutional amendment rather than an end run around the Constitution. Finally, Section 15 casually eliminates in a single sentence all of the provisions of NRS 293 that govern state and county central committees, precinct meetings, and conventions. This language is not amended, nor is it replaced with anything, simply repealed in its entirety. These sections of Nevada law have been in place since 1960, and they're the only section that authorizes and directs how political parties operate. Maybe that's a good thing, maybe it's not, but I'm not sure that we have given enough thought as to what structure will replace this repealed law. Section 15 got no discussion on the Senate side of the building when this bill was passed, only a passing mention that it existed. Only today, for the first time, was there some discussion of the motivation for the change. Because it forms the very foundation of how major political parties operate in Nevada, it seems incredible that it would be repealed as a tacked-on afterthought to an unrelated bill with little discussion or debate. There's insufficient time with just a few days remaining in this session for the parties to properly review and determine if this is appropriate legislation or not. Senate made a serious error when they passed
your 2 minutes are up.
without complete
Sir,
debate.
your 2 minutes are up, so if you
Okay,
have
I hope one last sentence. I hope that the Assembly will not repeat the Senate's grave error in passing this bill without fully discussing and understanding all important sections of the bill. Thank you.
Thank you.
Thank you, caller. Caller with the last 3 digits of 105. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good evening. My name is Lynn Chapman. I'm the State Vice President of Nevada Families for Freedom, LYNNCHAPMAN. Please oppose SB 292. The National Conference of State Legislatures in 2020 stated, quote, the number of states offering straight ticket voting has been declining in popularity over time, unquote. Utah abolished it in 2020. Pennsylvania abolished in 2019. New Mexico abolished in 2001. They tried to put it back on, but it failed. Iowa abolished in 2017. Texas abolished in 2017. Indiana abolished in 2016. Rhode Island abolished in 2015. West Virginia abolished 2015. North Carolina abolished 2014. Wisconsin abolished in 2011. New Hampshire abolished it in 2007. Missouri abolished in 2006. Illinois abolished in 1997. South Dakota abolished in 1996. Georgia abolished in 1994. Jeff Bray of Michigan said, quote, I almost didn't vote. I almost said, well, if I can't vote for who I want, then I'm not going to cast my vote. I think it turned a lot of people away. Maybe there are a lot of people that didn't vote because of that, unquote. I think it causes so much confusion and so many problems. I think it's a bad idea to go forward with this bill. I think it would cause even more problems if people can't even find a way to put their ballots in their little envelopes and try to get it back to the registrar's office. We had a lot of problems with that. I think this is going to cause even more confusion. Please oppose SB 292. Thank you.
Thank you.
Thank you. Caller with the last 3 digits of 373. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good evening. My name is Bob Russo. That is BOBRUSSO, and I oppose Senate Bill 292. A major problem I see today is an electorate that is becoming less informed on how our government functions and who vote based on what the government is willing to give them instead of what is best for preserving the inherent qualities of our republic. Voting is an incredible gift that we each take to the voting booth. Ideally, we carefully review each candidate to make sure that they support the values we hold dear as Americans. Unfortunately, Senate Bill 292 and straight ticket voting does just the opposite. It devalues voting and encourages people to be lax and neglectful. As Janine Hansen just mentioned, nonpartisan race positions and ballot questions can also be overlooked that tend to be at the bottom of the ballot. And further, it could cause some members of the legislature who are doing a good job to be voted out of office. Plus, this bill transfers the power to fill legislative vacancies from the counties or county commissioners to the state legislature. I do not support this. I believe that county commissioners have a greater view of the candidates who can meet the needs of their counties better than the state. Senate Bill 292 also requires an additional costly special primary election for a total of 2 primaries to fill a vacancy. This is unnecessary and another case of fiscal irresponsibility. I believe that the more informed the electorate is about the candidates they elect, the better qualified the candidates will be to serve the people they represent. I urge you to please vote for an informed and educated electorate by voting no on Senate Bill 292. Thank you very much.
For those of you that recently just joined us, we are currently still in opposition of SB 292. If you would like to testify in opposition, please press star 9 now. Chair, you have no more callers in opposition at this time.
Thank you. Can we open it up? Is there anyone here in the room? It doesn't appear anyone's here for neutral. Is there anyone on the line that would like to testify in neutral for SB 252? 292? Please don't testify for 252. 292?
If you would like to testify in neutral on SB 292, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 779, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Hello, it's Richard Winger, Winger. I'm neutral on the bill, but I urge you to delete the part of the bill that makes it more difficult for minor parties to get on the ballot. In 1984, the Democratic National Convention passed a resolution. It said, no task of the Democratic Party is more important than protecting the right to vote. The part of the bill that makes it more difficult for minor parties to get on the ballot is an anti-voting rights measure. Nevada hasn't had a party qualify in 10 years. And as far as the idea that the deadline has to be moved earlier because the state needs more time to adjudicate, that it's very rude of me to say the word phony. I feel bad being rude. I do not want to be rude, but that is totally phony. And here's the evidence. The Nevada law on how an independent presidential candidate gets on the ballot has a deadline in August for the Secretary of State to receive the signatures. And the work has to be done in July. The number of signatures for an independent presidential candidate and a new party is the same. How is it possible that this bill seems to leave the August deadline in place for an independent presidential petition deadline and feels that it's necessary to move the earlier party deadline? It just doesn't make sense. And finally, as to the distribution requirement, there are 8 states that have a distribution requirement, but none of them is worded as badly as this one. The typical state says...
Your 2 minutes is up.
Are we done?
Yes, we're done.
Okay, thank you.
Thank you. And I'm actually going to move your statement to opposition because that wasn't, according to our committee rules, that wasn't neutral. So you will be moved into the opposition for that bill. Broadcasting, next caller.
That's fine.
Thank you, Chair. You currently have no more callers neutral at this time.
Okay, thank you. With that, I will go ahead and close testimony for that in neutral. It appears the senator does have final comments to make. So if you could make your final comment, Senator.
Thank you, Madam Chair. I'll make them short. We all have a lot to do. I just want to clarify on the straight ticket voting. When you have straight ticket voting, you can vote your party or you don't have to vote your party. It's equal access for all parties. Independents can vote on either party all the way down or an independent candidate. They're all going to be listed on the ballot. It just provides an easy way for people that don't want to have to fill in every single election or every single candidate to be able to vote a straight ticket. So I think it does not also, and the other thing that's really important, it does not say that you shouldn't look into the candidates and figure out who they are, because if you're going to cross lines and vote, not a straight ticket, you want to know who those people are. So I think it provides everything that the opposition was asking. It just is, they're hearing it different. So thank you so much. I urge your support.
Thank you, Senator. And with that, I will close the hearing on SB 292. We're actually going to take a moment. I see our next presenters, our senators here to present, but we're actually going to work session a bill right now. So we're going to shift gears a little bit and work session a bill. So I will turn it over to our policy analyst, Mr. Sturm.
Thank you, Madam Chair. The bill for work session today is for Assembly Bill 432. That was heard on April 6th, and that was the bill that expanded automatic voter registration requirements to certain executive branch agencies. The measures specified these agencies include the Department of Motor Vehicles, Department of Health and Human Services, and any agencies within DHHS processing applications for Medicaid, the Silver State Health Insurance Exchange, and any other state or tribal agency meeting certain requirements as approved by the governor. The bill also sets forth procedures for processing applications, for transmitting the information, and the process for determining if the information is complete. Finally, the bill specifies that the statutes comply with the automatic voter registration. Agencies must comply with the National Voter Registration Act, which is 52 U.S. Code sections 2051 et sec. And we had an amendment proposed by Assemblyman Watts that presented the bill. He submitted a bill to revise the effective date of the bill, which is section 36(2)B, from January 1st, 2022, and instead make that effective date January 1st, 2024. The intent of the amendment was to implement the bill concurrently with the implementation of AB 422, if passed, which is that top-down voter registration system. And just a note, there were other amendments proposed by the county clerks and Clark County, but Assemblyman Watts has requested that the committee act on AB 432 without those proposed amendments while adopting his amendment concerning the effective date. Thank you, Madam Chair.
Vice Chair Howdiggy?
Thank you, Madam Chair. And just a clarifying question, because I know the sponsor, Assemblyman Watts, is currently chairing Growth and Infrastructure, so that the chair could join us. But I just want to clarify that the amendment is simply delaying the implementation date. Is that correct, Mr. Stern?
Yes, that delays the implementation date. That's the only amendment that Assemblyman Watts has requested that the committee consider for a motion to amend and do pass.
Thank you. And if there are no further questions, then, Chair, I would like to amend and make a motion to amend and do pass.
I will accept that motion. Do I have a second? A second from Assemblywoman Monroe. Let me back up. I am going to accept a motion to amend and do pass from Vice Chair Howdiggy, and then accept a second from Assemblywoman Monroe Moreno, so that we have that straight for the record. So with that, is there any comments or question on the motion? Not seeing anyone, I will take a roll call vote. A vote. All those in favor, please say aye. Aye. Anyone opposed? Nay. If you're nay, will you please raise your hand? Okay, so I have Assemblywoman Dickman, Assemblyman Matthews, Assemblyman MacArthur, and Assemblyman Levitt. And with that, the motion passes. So I will close the work session and move on to our next bill. So with that, I will open the work session on, oh, you're right, I'm going to open the hearing. We got to hear it before we work it. So I will open the hearing on Senate Bill 385. Senate Bill 385 is brought to us from the Committee on Judiciary, the Senate Committee on Judiciary, on behalf of the Legislative Committee on Child Welfare and Juvenile Justice. It requires the Division of Child and Family Services of the Department of Health and Human Services to conduct a study during the 2021-22 legislative interim concerning investments in juvenile justice prevention activities in the state. Senator, it's good to see you here as our my counterpart in the Senate, as you also chair Legislative Operations and Elections.
Good evening, Chair Miller, members of the Senate, or the Assembly Committee on Legislative Operations and Elections. For the record, James Orenshaw, represents State Senate District 21, and I appreciate you hearing the bill, and thank you for sending so many good bills over for our committee to hear. You know, our sister committee relationship here, I think, has worked well, and I hope we've sent you some good bills, but you've sent us a lot of great ones, so thank you. Senate Bill 385 came out of the Interim Committee on Child Welfare and Juvenile Justice. I was very lucky to serve with Assemblywoman Torres and Assemblywoman Monroe Moreno on that interim committee. During this past interim, I had the honor of chairing that committee. Assemblywoman Monroe Moreno was the vice chair, and we had Assemblywoman Torres, Assemblywoman Hansen, Senator Hammond, former Senator Cancella. We had a bipartisan group. We were very focused on trying to, of course, help children, but also in the juvenile justice arena, try to prevent children from ending up in deeper in the system, and trying to see if they can avoid state commitments, which means commitments to state youth correctional facilities. Try to keep children who do get in trouble with the law closer to home, try to promote diversion programs, try to limit their repeat times in court, and trying to see if we can get them out of the system and get whatever therapy and treatment might help them to them, but try to not have them get deeper into the system. And Senate Bill 385 is a unanimous bipartisan recommendation that came out of the interim committee, which was amended over on the Senate side, and the amendment did take away the fiscal note, so that made it a little more palatable for the Money Committee. And what we're asking in Senate Bill 385 as amended is for the Division of Child and Family Services to really study what they've been able to accomplish in terms of juvenile justice prevention, trying to keep kids from ending up in the system, and trying to promote diversion programs. We had great partners during the interim. I see Administrator of the Division of Child and Family Services, Ross Armstrong. We worked with Bridget Duffy. We worked with Holly Wellborn at the ACLU. And this bill here, I think, tries to further what's already being done and look at, where funds can be spent to divert kids from ending up committed to state facilities, and trying to keep them closer to home, and trying to make sure that hopefully they won't appear again in a court or on juvenile probation or youth parole. With that, I'm happy to answer any questions. I do see Administrator Armstrong on Zoom, and I appreciate all his hard work and commitment to youth in the state. And if there's a question I get stumped on, I'd ask the chair's permission to Zoom a friend on a lifeline, but I'm happy to answer any questions on this bill.
Absolutely. Thank you, Senator. And that's generally our practice here, is that members will direct their questions directly to you, and then you can defer when you feel necessary, okay? With that, members, do we have any questions? Assemblywoman Thomas.
Thank you, Madam Chair. And thank you, Senator, for bringing this bill forward. It's something that we really, truly need. But my question is, when we go to section 1.5, subsection 2, and you speak of the study must include a review of current investment in juvenile justice prevention activities within the state. It just kind of struck me, review the current investment. So could you explain what they are?
Yes. James Orenshaw, State Senate District 21, through you, Chair Miller, to the Assemblywoman. Certainly there are many, and if I miss any, I don't want to, hopefully, I didn't mean to exclude any, but there are programs in Southern Nevada, and my day job is a public defender in juvenile court, so I get to see a lot of what happens there. And down in juvenile court in Southern Nevada, Judge Bailey, Sunny Bailey, she started what's called the autism court, because we've had many kids who've been arrested, they get in trouble, and they're brought down to juvenile detention at Clark County, and a lot of times it wasn't ever discovered that they were on the spectrum. And she developed a court. She's no longer there. She moved on to district court, but she developed a court which tries to diagnose children and connect them with treatment, and very often the charges end up getting dismissed if that works. There's also a juvenile drug court down in Southern Nevada where kids can try to work on rehabilitation, on trying to get sober and stay sober, very similar to the adult drug court, but more tailored for children in terms of trying to get them therapy and trying to see if that can help them avoid getting in further trouble with the law. The Clark County has a tremendous program called The Harbor, which tries to divert children from going into juvenile justice court and ending up in delinquency court, either after a charge or sometimes before, which is a diversion program that I think has proven very effective. Those are just some examples. I know that on the state side, youth parole tries to help children once they've exited state youth facilities. I know juvenile probation does too at Clark County, tries to help kids get birth certificates if they're trying to get into a credit retrieval program, trying to get through and get their high school diploma or GED. So I think that there are many different programs that are trying to help children land on their feet and not get caught up back in the system. Certainly Judge Voy and Judge Gibson down in Southern Nevada, very often a court hearing, brings social workers together, folks from, the state facilities in terms of trying to find out, if maybe home's not an option right now, trying to find another placement where a child might do well and succeed. Our former colleague, Assemblyman Tyrone Thompson, was pivotal in trying to help starting the Shannon West Center for Independent Living for homeless youth. And very often kids who end up getting arrested and in delinquency court, if home either isn't an option or is such a bad option that the child's not going to succeed there, sometimes the court, social workers who work with the defense attorneys and the prosecutors will try to place the child there at Shannon West. So there are many options. I think that's just some of the examples. And I wasn't planning to Zoom my friend this early, but with the chair's indulgence, if I could Zoom Administrator Armstrong, in case I'm missing any, I'm going to reach out for my lifeline. Thank you, Administrator.
Mr. Armstrong, when you're ready.
Thank you. Ross Armstrong, Administrator for the Division of Child Family Services, and Senator Orenshaw hit on some of the great activities that are happening in terms of juvenile justice prevention. Just to understand the scale, the state of Nevada spends about $5.5 million in state general fund on juvenile justice prevention. The vast majority of that goes to our county camps, China Spring and Spring Mountain. For those of you that are on the finance committees, you know the discussion about the China Spring funding this session. That's compared to the $26 million a year we spend in corrections. And so one of the ideas of taking a look at the current investments in juvenile justice prevention is to look at the scale and their effectiveness. There have been kind of one-off bills in the past that fund specific programs. I think 2 sessions ago, there was a bill that gave each judicial district some money. And so part of it is taking a look at how we've invested in the past and determining if there's a better way to structure it. In particular, to take a look and see if there are any ways that we can encourage savings in the corrections arena and invest those savings in further prevention. So like I said, the specific program Senator Orenshaw hit on, but sometimes I think that scale, understanding we spend that $5 million on prevention, the most of that is on essentially corrections light, compared to the $26 million we spend on state juvenile corrections. Sometimes that scale is helpful in thinking about juvenile justice prevention. There's also a federal program. We receive a formula grant that's a couple $100,000 a year that we also grant out to local entities working in prevention work.
Thank you. Such a wonderful program. and you always bring our younger citizens. I've been listening to a couple of your bills, and I'm so impressed. I appreciate your service to our community. But I do have a follow-up. Follow-up, Chair?
Follow-up, go ahead.
Thank you, ma'am. What's the data like when you're showing success or failure rate with all of the programs? Do you have a spreadsheet that that you could look at? And I just want that for future reference. I don't need it right now. I just am asking.
Thank you. James Orenshaw, State Senate District 21, to you and through you, Chair, to the Assemblywoman. I appreciate your kind words, and certainly on the interim committee, Assemblywoman Torres, Vice Chair Monroe Moreno, and the other members, they were pivotal in trying to advocate for legislation to try to keep kids out of the system. Administrator Armstrong, Ms. Duffy, they were great to work with and just tremendously committed to this issue. For me personally, success means a child you don't see the child back arrested or in court again. The clients that I feel are my best successes are the ones I never see again, never hear from, because they didn't come back, didn't get in trouble again, didn't get a violation of probation or a violation of youth parole. As to data, that's been a struggle through the years, and I know that between the statewide Juvenile Justice Oversight Commission, the Division of Child and Family Services, the county juvenile probation offices, there's a big effort, and there's been an effort now for the last few years to try to get more data as to what's working, what isn't working, and I think that we are close to getting better data soon, but I think that it's still a little ways away, and if I could, again, defer to Administrator Armstrong, he might have a little more current information on where we are at with data, but I think that we're close to getting good data, but if I could defer to him.
Yes, again, Ross Armstrong for the record. In 2017, the legislature passed AB 472, which was the Juvenile Justice Reform Act of that year. And in that bill, it required that all of our juvenile justice serving agencies get on the same data system. And so we are there now, and we are able to, we are working now on building those reports to better track the youth from our county probation departments to the state. So for those of you maybe not familiar with juvenile justice, our county probation departments, our counties do the bulk of the prevention work in the community. Those cases that are escalated, where there's a high risk to the community and complex needs of the youth, are committed to state custody. I can tell you that we've made tremendous progress. Just maybe 3 or 4 years ago, we had an average of 200 to 220 youth in our state facilities at any given time. As of the 19th of this month, there were only 133 in our state facilities. And so we don't have good data right now in terms of does this particular program, how many youth were saved from going to the state, but we're getting there with our data systems and being able to track that. But we don't have that information right now.
Thank you, sir. Thank you, Chair.
Thank you. Members, any other questions? All right, doesn't appear that we have any additional questions. So with that, thank you, Senator. I will go ahead and open testimony for anyone. There's no one else in the room, so I know there's no one in the room, but for anyone broadcasting, if there's anyone on the line that would like to testify in support for SB 385.
Thank you, Chair. Your public line is currently open and working, and you have no callers at this time.
Thank you. Do we have anyone interested in calling and testifying in opposition of SB 385?
Chair, your public line is open and working, and you have no callers in opposition at this time.
Thank you. Do we have anyone in online for neutral?
Your line is still open and working, and you currently have no callers in neutral at this time.
Okay, thank you for that. So I will go ahead and close the option testimony. Senator, would you like to make any final remarks?
Yes, thank you, Chair. James Orenshaw, State Senate 21. Thank you for hearing the bill. Again, these bills, I think, represent that interim committee. I was so lucky to serve on that interim committee. During this interim, we were able to have 2 in-person meetings at the Grant Sawyer State Building before the pandemic hit. Then the pandemic hit, and we weren't really sure what we were going to do or how we were going to function, but LCB, Broadcasting, Patrick Guinan, Eileen O'Grady, Carly O'Krent, just tremendous staff that helped us kind of learn this technology, and we were able to have 6, I think it was 6 more meetings via Zoom and recommend 10 bill drafts. This is one of them, and we did have to amend it a little bit due to the fiscal note, but I still feel that this is something that will help the interim committee on child welfare and juvenile justice and help the legislature in 2023 try to work on the goals of less kids getting committed. And it sounds like we've already, made a lot of progress, hearing Administrator Armstrong. But thank you for your time. Appreciate it.
Okay, thank you for that, Senator. And with that, I will go ahead and close the hearing on Senate Bill 385. And members, I'm going to ask you to just take a pause for just a moment. Not a recess, just a pause. Okay, members, we are going to go ahead and work session the bill that we just heard, Senate Bill 385. Didn't seem to be too many questions or complications, so I'm gonna turn it over to our policy analyst, Mr. Sturm. Give him a few minutes to collect his thoughts, because as much as we think things move quickly for us at this point, it moves even faster for LCB staff. So we'll give him a moment, and when you're ready, Mr. Sturm.
Thank you, Madam Chair. Pepper Sturm, your committee policy analyst, LCB. We just heard Senate Bill 385, presented by Senator Orenshall. Heard today, this bill requires the Division of Child and Family Services to conduct a study over the 2021-22 interim concerning investments in juvenile justice prevention activities in the state. Study must include a review of current investments in juvenile justice in the state, a survey of best practices and funding mechanisms for juvenile justice prevention activities in other jurisdictions, and recommendations for improving investments in juvenile justice prevention activities in the state. The Division of Child and Family Services is then required to submit a report to the Juvenile Justice Oversight Commission and to the Legislative Committee on Child Welfare and Juvenile Justice by August 1st, 2022. There were no amendments proposed during testimony to this bill. Thank you, Madam Chair.
Thank you, Mr. Sturm. With that, members, do we have any questions? Not seeing anyone, I will accept a motion.
I'd like to make that motion to do pass.
Okay, we have a motion to do pass by Vice Chair Howdigi for Senate Bill 385. Do I have a second? A second by Assemblyman Levitt. Members, any questions or comments on the motion? All right, with that, we will go ahead and take a vote. All those in favor, please say aye. Aye. Anyone opposed? Okay, we have one from Assemblyman MacArthur. Anyone else? Okay, with that, the motion passes with the members that are present. And I feel like Assemblyman MacArthur always knows when I'm looking at him to give him a floor statement so that he knows to oppose the bill, because then it would be super awkward and I would never do that. So instead, I'm going to assign it to Assemblyman Levitt. All right. With that, we will close work session and move on to our final item on the agenda, which is public comment. So we will take up to 30 minutes of public comment. Broadcasting, please open the line.
Thank you, Chair. Your public line is open and working, and you have no callers at this time.
Okay, we're going to wait just a minute because I know anyone viewing on YouTube or Nellis may be a minute behind.
Standing by. Thank you, Chair.
Broadcasting, is anyone on the line?
Chair, your public line is still open and working, and you have no callers at this time.
Okay, thank you. With that, I will close public comment. So with that, we have finished all of our business for the day. I would like you members to know that we will have a meeting on Thursday at 4 o'clock or 4 o'clock-ish on the 27th. And it will be primarily at this point to work session a number of bills that we still have. We may be hearing something new. It all depends. You know, there's a lot of moving parts and things change rapidly at this point in session. So please do plan on having another meeting. And it also stay tuned because there may be some other call of the chairs meetings that are thrown up. But with that, we are done for the day. So this meeting is adjourned.
Ms. Stickman, if you would stay on.